Welcome back. Quite an engaging segment with Professor K. Kechuku. Always a delight to have him. So we're going to have him back because there's a lot he has to unpack for us. But for the shortness of time, we need to wrap up. But let's bring in our next conversation, which has to do with the pronouncement of court we saw yesterday. It was televised all across the country and around the world. The sentencing, the conviction and sentencing of Mazi Nnamdi Kanu, the leader of the proscribed indigenous people of Biafra, who is now an ex-convict by the pronouncement of the court, and he's been sentenced to life imprisonment on the charges that had to do with terrorism. Other charges about 20 years and 5 years apart, running concurrently. Although in their locutors, the prosecuting counsel has sought for a death sentence, but the judge refrained from that for the reasons he stated. But let's see and unpack the legalese and the wider implication as far as our jurisprudence and the social impact of that judgment is concerned. Festus Ogun is our guest. He's a legal practitioner joining us right here in our Lagos studio. Mr. Ogun, thank you so much for coming on the program.
Thank you very much for having me here.
I know I'm sure you watched part of that long proceedings at the Federal High Court, Justice James Omotosho, and then all the drama that played out, eventually the pronouncement. So something that started with Justice Binta who went all the way to the Supreme Court, went back to the Federal High Court, and then now 7-count charge, found guilty on all. And then at some point, he was a pro se litigant. And that, whether it was a strategy, we don't know. But now, this is where we are. What do you make of this case?
Well, I watch in part the live coverage of the judgment that was delivered by Honorable Justice James Omotosho. And I've also had the privilege to read through the 144-page judgment of the court. I mean, it's already in circulation, the certified true copy of the judgment. And all I can say is that the court has spoken, and the court has spoken quite loudly. The court has found him guilty of all the charges, the 7-count charges that has been levied against him. But looking at it critically, I do not have any blame on the trial judge. He has done his work as a judex. He has delivered judgment in the case as he has seen it based on the evidence that has been presented before him. But I'm a little bit worried in all of this. I'm a little bit worried about a strategy that was deployed by Nnamdi Kanu and his maybe legal consultants, or I would say legal team. Even for the most frivolous charges, you must, as a matter of strategy, in fact, as a matter of responsibility, no matter how strongly you feel about your case, even if you feel that the prosecution has no case, you must present a defense. That is why you are called a defendant. You have been called upon. Oh, these are the charges levied against you. You even raised a no-case submission that I do not have a case to answer based on the evidence led by the prosecution, that there is no prima facie case established against me. The court disagreed with you that no, there is a case for you to answer. Now, it got to the turn where you would answer the case before you. You opt not to answer the case. It's troubling. I'm not saying that even when you refuse to answer a case that has been levied against you, even if you choose to present a defense, I'm not necessarily saying that it automatically means that you are guilty. Even when there is a prima facie case against you, it does not necessarily mean that the case has been proven beyond reasonable doubt. It only means that the case presented is worthy of answers. It doesn't mean that the case has been proven beyond reasonable doubt. So even when the court said, look, you have a case to answer, it doesn't necessarily mean that the prosecution has presented a case beyond reasonable doubt. But again, when you see that there is a prima facie against you, it could also mean that there is a case that has been established against you beyond reasonable doubt. So it was a miscalculation for you not to have presented a defense.
What if it was deliberate? I think also looking at the way, something that Jeffrey said earlier, which is of course part of what everyone has seen and has been widely reported, the fact that the fellow said, look, as at the time this incident occurred, there was no law that said I couldn't do it. So there was no basis for accusing me when there was no law at the time.
Well, you see, as much as I'm not sympathetic towards IPOB, but I am sympathetic towards what I have considered as historical marginalization of the Southeast. But that does not deter me from saying the truth. If you feel like, there was no law, you bring an objection procedurally. The court of law is a court of justice and a court of procedure. Even when you feel like, I have a strong objection against the law upon which I'm being tried, you owe the court a duty to file the necessary application before the court. The court has rules. There is a Federal High Court Civil Procedure Rule 2019. And this rule guides the procedural steps with which a defendant or a claimant would bring any application or tender any grievance. I think it is out of place for a defendant to just, in the dock, start making assertions that are quite provocative. The best he could have done is to file an application or allow his lawyers file an application to say, this law upon which I'm being tried has been repealed. And that is if the claim is anything to go by.
Interesting. I also find it very, very interesting. I don't know if it is something significant that in the judgment, the defendant was the only name mentioned, none of his lawyers. I mean, he had lawyers before that time, right? And at some point, all of them they became consultants and not legal representatives. And he was the only one mentioned. So how significant is that? In addition to the fact that if there is going to be an appeal, will he be doing it by himself or is he not going to get lawyers? Where do you see this going from here? Because it seems like it is clear. This is the position of the court and that's the position of the judiciary, unless another judgment overturns it. So how do you see all this playing out?
To start with, on the issue of having his name on the judgment, the position is usually that the person that appears on the last day that the judgment is read is whose name will be inscribed on the face of the judgment. Not everyone that has started the matter, no. At the time the judgment was delivered, Kanu was representing himself. But I find it a bit curious, and with the greatest respect to our learned colleagues that represented, that were representing him and were debriefed. And in spite of being debriefed from continuing with the matter they had started over the years, they still strangely were found to be consultants. I find that strange. That's the first time I will be hearing something like that. That you have been debriefed as a lawyer, yet you are still acting as a consultant to the person that has debriefed you. It doesn't speak well of us. And I say that with the greatest respect to them. Again...
What does that mean?
It's a question...
What does it mean to a lay person? For you lawyers, I'm sure... So, for the purpose of general reference, there were counsels. They're now metamorphosed into consultants. I know that even generated a bit of issue at some point when Justice James Omotosho was insisting on a few things. So what does that mean as far as the legal space is concerned?
Well, a legal consultant is a lawyer that gives advisory to a client. A counsel is he who appears in court on behalf of a client. But if you are a legal consultant, what business have you in the court in a case that your client had even debriefed you earlier? For me, we are called counsel because we give counsel to our clients. We are called counselors in America. Lawyers are called counselors because they give counsel to their clients. And it takes a bit of professional dignity and professional respect. For a client to debrief you, no, you are not representing me in this matter. And the same client has now told you, so come and be my consultant, after I've told you to stop representing me.
Okay.
I'm sorry. And the most critical stage is the stage where the court has said there is a prima facie case against you. I've said it that it's not automatic that they are proving their case beyond reasonable doubt. They say there is a clear case that you need to answer here. It is at that stage that you are asked to leave. Who would have expected an alternative or a different decision?
Okay. Let's build on some of the legalese. And I want to, let's dwell on what he kept saying. Now, I think he referenced, Nnamdi Kanu, before he was taken out of court on the order of the judge. He kept referring to, I think, a pronouncement by the Supreme Court, which the judge referenced, because it became the judge, all of the preliminary objections and all of that, he had to sort it out before he went to the substantive issue.
Yes.
He said, repealed law has no life in law. That's, I think I heard that from the Honorable Judge, Justice James Omotosho himself. Now, the argument is that there was a 2011 anti-terrorism amended to 2013. This, whatever happened in 2018, 2017 or so. And then we now have a 2022 that repealed 2013 Anti-Terrorism Act. So he was standing on the fact that that is his own understanding. Now, for the fact that this happened in between the two, and the other one has been repealed, and given the pronouncement of the Supreme Court that a repealed law has no life in law, it doesn't have anything to answer, and he became a bit a rowdy session where he was telling the judge, you know, you don't know law, blah, 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 and all of that. What does he have a point in what he's saying? Because the judge explained this on why he can be tried on, I think, the 2022 Anti-Terrorism Act. Does he have a point? Because I think that's why he refused to put up a defense, which has led him here.
What we are calling repealed law, they are amended laws. They are amended laws. And should we, because a crime has been committed before now, and there was an amendment, let's even say there was a repeal and there was a reenactment of a new law, should we forgo the crime that has been committed? And again, this is without prejudice to Nnamdi Kanu. But the fact that a crime has been committed against the Nigerian state would not be forgotten or excused because a law has been repealed or a law has been amended. So long as the tenor, the tone of the amendment is still in line with the crime that has been committed, it is a different case to say that, oh, there was never such crime. And that as of today, there is a new law that has been enacted, and you now want to apply the law retrospectively. Sorry for cutting. I'm sorry.
Just to add to it, what was he trying to say? Was he trying to say, I committed this crime, but you don't have a law to try me, or I didn't commit this crime at all? What was he trying to say with this, with this strategy?
I do not equally understand it, but the position of the law as I know it is that, yes, when a law is enacted, if a new law is enacted, you cannot apply the law retrospectively. You cannot apply the law retroactively. But that notwithstanding, where there was a law in force, prior to the time there was an amendment or there was a repeal and there was a reenactment, that will not excuse you. And again, we must also be very careful. Some of these crimes that were alleged in the charge were continuous.
What does that mean?
Oh, even when he was arrested in 2015, after his bail was granted, the whole issue that happened in his country home, when he fled the country and all of that, the federal government was still insistent on the fact that the crime that he was committing had not stopped. The broadcast did not stop. His utterances that the federal government alleged there were terrorist tendencies never stopped. So that argument that he was trying to make may not be legally sound. But I mean, by and large, I think that what Justice Omotosho had done I'm not talking about the outcome of the judgment now, because a trial judge has a right to be wrong, and he has a right to appeal. But what Justice Omotosho had done in respect of managing the case must be commended. If we are not commending everything, even if we are not totally satisfied with the outcome of the judgment, even if I feel that the matter ought to have been approached, the old prosecution of Nnamdi Kanu ought to have been approached in a more better way, or in a more political manner, I think Justice Omotosho must be commended by every Nigerian, and I will tell you why. The reason is because this trial started in 2015. And
under him?
Not under Justice Omotosho.
2015 under Justice Omotosho.
Under Justice Omotosho, yes. And
No. It started with under Justice Omotosho this year.
Yes, this year.
Yes, 9 months.
Within 9 months, we were able to conclude a matter that has started since 2015. And there are rigmarole. Judges are recusing themselves from the matter. There were delays. You see that what took us a 10-year journey was courageously and craftily concluded within a year by Justice Omotosho. And that shows the possibility in our criminal justice system. I can tell you that Simon Ekpa was arrested last year by the Finnish government. And he was convicted this year, barely within a year. But over here, it takes us almost forever to prosecute accused persons or defendants. And that is why I feel that no matter how you look at it, for Justice Omotosho to say, look, come, let's be serious here. Whatever objections you are filing, put up everything together. He was courageous enough to manage the matter, and he was able to deliver,
I guess,
within reasonable time. I think that is commendable, and I commend him for that.
It's a whole load of issues that one would want to look at as far as this matter is concerned. The only question is, where do we go from here? Where is this case likely to? What are the spin-offs that are going to come in the coming days, weeks, and months? If you can do this in 60 seconds.
2 things. 1, as much as I commend Justice Omotosho, the trial court has a right to be wrong. The only option, as of today, the first option that lies before Mazi Nnamdi Kanu is to allow his lawyers, because you must not underestimate the work of a lawyer, is to allow his lawyer look at the papers and possibly put up an appeal, because he has a right of appeal under the Constitution. That is 1. The point I've been echoing, even at the last time I was on this show on this point, was that for me, I still maintain my position that the whole agitations in the Southeast, the whole issues of marginalization in the Southeast, and by extension, the prosecution of, and now conviction of Nnamdi Kanu, should have been approached from a political perspective. I urge the president to look at it. He has all the powers under the Constitution to resolve this issue in a more political manner.
Even though there were treason charges?
I mean, we must look at the offshoots. The agitations of young persons in the Southeast, including, if we look at it critically,
you also
the agitation...
I'm almost certain you heard what Jerry referenced earlier on the program, that, look, there are better ways. Even the judge said that there were better ways to have approached all of those issues that were being raised. Mr. Ogun, we could go on and on.
I feel it can be approached in a more political manner.
It's sensitive. I understand the marginalization part, and I don't think anybody's in doubt of that. In fact, it's not just Southeast. There's not Central. There are agitations here and there. In fact, maybe one day we'll talk about marginalization. It's part of the conversation Nigeria avoids. But our job is to mainstream it, so that we'll look at ourselves and say,
and tell ourselves,
you've not been fair to us, you've not been fair to us, you've been fair to us. Everybody sits down and begin to look for a future. Because if you look at Section 14 of the Constitution, I always reference that section, and it's wisdom from the framers. They said, when it comes to federal character, the language that was used, sense of belonging.
Yes,
was used as a language in the Constitution.
And that is the foundation of the agitations of the IPOB.
Yeah. All right.
Other persons in the Southeast.
No,
And that is why I feel that.
When we do that marginalization roundtable, it's going to be sunrise, morning brief, collabo. Thank you, Festus Ogun. Thank you for coming on the program. We appreciate you.
Thank you for having me.
All right, we'll take a break now. When we come back, we have more to talk about in just a moment. Stay with us.